Delighted to be here. I was a law clerk to Justice Brennan, so I have a particular fondness for the work of the center. And I also have a great fondness for Rick, even though I'm about to demolish him. But I'm actually here as the devil's advocate. And in that context, let me say a few words at the outset to explain why I am in that role. I'm a strong advocate of free speech. So I come to this not, in fact, as a conservative, but as a liberal. And it's people like Rick who have betrayed their liberal values. Now, the issue here is not what's the right result in Citizens United. It's instead a question about a particular argument that might or might not be helpful to defend the position of the dissenting justices in Citizens United. But the larger question of whether Citizens United was rightly or wrongly decided does not necessarily turn on this argument at all. Indeed, in the McConnell case, in which the court reached the opposite result from Citizens United and upheld the relevant provisions of the McCain-Feingold legislation, the justices didn't say a word about electoral exceptionalism. They upheld the statute on the basis that it met the standards that ordinarily apply under the First Amendment. And so whether one agrees or disagrees with the premise that there should be a perspective that dilutes the protection of the First Amendment under the name of electoral exceptionalism, that does not go to the question of whether the legislation is in fact constitutional or not. That's an important thing to keep in mind. So my argument is not that the majority was right, it's only that Rick is wrong. Okay, so actually I'm all in favor of the doctrine of electoral exceptionalism. That is, if anything, we should grant greater protection to free speech in the electoral context, because that is, at its very core, the heart of what the First Amendment is about. So if anything, the power of the government to interfere with free speech in elections should be at its minimum, because it's in that context in particular when we have every reason to distrust the government when it attempts to muck around with free speech in the electoral situation. So I'm actually all in favor of electoral exceptionalism, but it cuts in the opposite direction from Rick's. What Rick is arguing, it's important to keep this clear, is that free speech gets less protection when it's involved in an election than otherwise. And to me, that's a fairly perverse argument, although I do understand the logic of it. So let me say a bit about the underlying logic of the position. It is true that first there are these generalized off-the-rack standards that apply in most circumstances involving free speech, under which the law at issue in Citizens United is either constitutional or not. If you believe the majority in McConnell, it's constitutional. If you believe the majority in Citizens United, it's not constitutional. It's also true that under those generalized standards, there are exceptions. As Rick points out, there are circumstances in which the court says the ordinary protections of the First Amendment do not apply in the same way in some circumstances. And those circumstances are illustrated by some of the examples that Rick identified. For instance, the basic standards of the First Amendment do not apply in full force in situations involving public employees. They do not apply with full force in situations involving free speech by students in public schools. They also do not apply with full force in town hall meetings or in prisons or in the military or in courtrooms or on ballots. That is, there are lots of circumstances in which, for a variety of reasons, the court has reasonably held that to apply the basic protections of the First Amendment in full force would wreak havoc with particular institutional settings which are just not designed at all to deal with the demands of free speech. So think about trials, right? A trial could be held, in theory, according to the rules of free speech, but all you have to do is take a second to imagine what it would look like, right? Everybody could speak all they want, no rules of evidence, and it would be a total free-for-all, like the marketplace of ideas. And whether that would, in any conceivable way, achieve the goals of the litigation system, of the justice system, seems extremely doubtful. So we allow all sorts of regulations of speech, even though it's a government, trial's a government activity, that we would never allow in ordinary public discourse. We allow rules about who speaks first and who speaks second. We allow rules about what questions you can ask, about how they can be framed, about what answers can be given. We exclude certain types of information from the consideration of the trier. Think of the trier being the public in an electoral context, because it's hearsay, and we don't trust the trier of fact to hear the evidence, or because we think it's unduly prejudicial, and we don't trust the public to hear the information. None of those rules would be constitutional in public discourse, but they are constitutional in the context of a trial. And Rick's argument is that elections should be treated the way we treat trials. That is, we should exempt them from the basic standards of the First Amendment and allow the government to regulate what can and can't be said and by whom and when in elections in much the same way, not exactly obviously, but in much the same spirit as we do in the context of trials. Now, there's a good argument for that. We know that the free market in the political process can produce dysfunctions. It can produce bad outcomes. People may hear bad ideas or irrational arguments. And some people may speak more than other people. And some people may have more money to speak than other people. And as a consequence, the system may not reach what Rick believes to be the right outcomes. And may even think, more neutrally, that it's not the ideal system. We can make a better system in this context than if we simply treat this like the free market and ideas. So the question then is, well, why shouldn't we just adopt this approach? Why shouldn't we say that, well, elections are like trials, and we should follow that analogy, or that they're like students in a public school, or they're like public employees, or like people in prison, or people in the military? Well, there are a lot of answers to that as to why we should be skeptical about this argument. For one thing, elections are not a closely organized government activity that has historically involved, as a part of its very nature, a degree of discipline that we've come to understand is necessary for that institution to operate at all effectively. Schools cannot operate effectively if you can't have some discipline in the expression of students. Prisons can't operate if prisoners have the same free speech rights in all respects as ordinary citizens. Courtrooms, certainly, as we've seen, cannot do this. Is that true in the electoral context? I think the answer to that is no. That one might argue that we might be able to get better electoral outcomes and a better electoral process if we regulate it, but one can't say it's essential to the very function of the activity itself. And therefore, one would argue that if you want to make that argument, you've got to demonstrate that there's a highly compelling justification for allowing the government to regulate this type of activity in a way that it's never attempted to regulate it in history. Because once you accept the premise of electoral exceptionalism along these lines, you open the door to a whole range of possible regulations, not just the ones involved in Citizens United. Suppose the government decides it's a crime to make a false statement of fact in the context of an election campaign, as would be true for a perjury statement, for example, in a trial. or it's unlawful for anyone to make any argument in an election that is unduly prejudicial, that may inflame the electorate in a way that leads them to behave in a way that the government deems to be irrational. Those arguments would immediately become plausible as soon as you say, well, we're no longer going to apply the ordinary standards of the First Amendment, under which those would obviously be unconstitutional. They all become now fair game. Now, the other thing Rick doesn't really ever say about this is, well, what standards do apply in the electoral context if, in fact, we were to go this road? If we took this approach, what else besides the law that was invalidated in Citizens United then becomes constitutional? And what rules might people who were not so sympathetic with, might they put into the political process? Because they think it leads to a better process. Are we prepared to give elected officials, who may often be people we don't trust or like, the authority to mess around with the electoral process in ways that we may not find congenial at all? Because that's what you're opening the door to once you eliminate the high bars to regulation in this context. I, for one, am very distrustful of government when it comes to this context, and particularly so when it comes to regulating the political process, because there's a huge fox and hen house problem. And I think, therefore, courts should be especially vigilant in thinking about regulations of elections by elected officials, not especially deferential. And therefore, I'm very skeptical about this idea of electoral exceptionalism, as Rick has put forth. Again, to underscore, that's not to say that I think the majority was right in Citizens United. The only thing I think they were right about was they applied the same standards of the First Amendment that we would ordinarily apply in other settings, as did the dissenters who reached the other result. Thank you.